appeal in the matter of Decision Inc Holdings Proprietary Ltd and another, and Garbett and another. Go ahead.
Mr. Warwick. Oh, sorry, Mr. Lowe.
Apologies, my lord. If I may, just a point on which your lordship asked me to take instructions yesterday, which was hypothetically, if it were to come to it, in relation to the counterclaim and what my client's preference would be in terms of remedy, taking instructions, the answer would be, if it were down to them, they would prefer cash. Obviously, you'll hear from Mr. Warwick on that point, and if I need to come back on that, then I will.
Thank you.
I'm grateful.
Sorry, Mr. Warwick.
Yes. My lords, my lady, I'm going to follow the same order of issues as Mr. Lowe, and that means I'm going to take round 2, as it's called, which is the construction of the prospects warranty first. You'll probably already know what it says, but the reference is Core Bundle 210. If I can make 4 preliminary points. The first is that the parties chose to include prospects in the warranty, which also referred to turnover and financial position. Self-evidently, therefore, prospects means something other than those 2 words. Secondly, in answer to the question, what else, you apply orthodox principles, which means that, for example, Wood and Capita and all others too well known to mention, and that means you look at the background, rather sometimes called matrix. Now, the background, this is point 3, is a matter of evidence. The judge was at pains early on in his judgment to describe the background, and he did so at paragraphs 6 to 11. And a little oddly, this isn't something that Mr. Lowe referred to in his submissions, but it is very important in the context of this case. And so what I'd like to do is take you in the core bundle to the passage where the judge literally has a section on page 43, headed background. Now, I'm sure that all will have read paragraphs 6 to 11. What are particularly important are everything from halfway down 7 all the way through to the end. I could invite the court to pause now and read those paragraphs, but I'm hoping that they will be in the forefront of your view. I'd like to summarise, or rather emphasise, 5 points that really emerge from those paragraphs. The first is the end of paragraph 7, and the very last sentence. In summary, the continual winning of a few large mandates is essential to the business. In the paragraph 8, there's a reference to the conventional industry approach in a business of this kind is to compile a pipeline, and there's specific reference in the 3rd line of paragraph 8 to a pipeline document to include everything from a remote prospect to a concluded agreement. It lists the identified possibilities. Then paragraph 10, the first part of paragraph 10, it's common ground between the parties that in assessing the value of the company, the focus of both sides in the negotiations was on the company's ability to consistently generate future revenues. And then at the end of 10, the future profitability of the company was entirely dependent on the company's own ability to generate new business. And then lastly, last but not least, paragraph 11, the discussions between Decision and the defendants in negotiating the deal turned significantly on the future business the company might be expected to win. To provide comfort to Decision as to the future potential, the company information was provided at various points as to the pipeline of the deal. And this was a list of potential assignments which the defendants believed the company might win. And then the most significant elements in the pipeline were the 4 clients, and they're identified, BBC, TfL, Kerry and Nidec, known throughout as the 4 contracts. So that background is very important, and I don't understand any of it to be disputed by the defendants. Now, a key part of the background, as is plain from what's said there, were pipeline documents. And I apologise in advance if I will be stressing as we go along pipeline documents. those documents, which in particular, and the ones that we pleaded were 217 and 239 in the supplementary bundle, they describe the company's prospects. And you could also describe them as prospect documents. Now, you've been
Are
shown...
they so described at any point in the original documents?
In at least one place, internally to the defendants, there is a reference to prospect documents or documents dealing with prospects. And I'll show you what there is about that. You've been shown briefly the May pipeline document, which is SB 217, but you weren't taken to, although you may have looked at, SB 239. Since this was the document referred to most for the purposes of the trial, it's probably appropriate that I turn to it now, because I'll be referring to it from time to time. And this document, this July pipeline, was never changed. It was the pipeline that was still operative at the time of the agreement. So in the supplementary bundle, it's page 239. I should date it for the court. If you go back to page 232, you'll see that there's an email from Mr. Garbett on the 24th of July at 13:18, sent to Mr. Bell of my clients and copied into various other people, subject project information. If you look at the third line, we are happy with the plan we worked on with you, and I have attached the updated pipeline plan. So that's when it came to us, and so you turn to page 239 and you see at the top customer Copperman Sales Pipeline July 2018. You've got a customer name. So the structure to this is the same as the structure to the main pipeline that you were shown. You've got a customer name, an opportunity, a value, and then you look along, and for this one, in the headings, the last actual heading is July status, but then it's followed up with some commentary. Now the four entries that we need to look at are all in the lowest segment. So the first is new TFL, Transport for London, re-implementation of something, and then there are two figures given, 1.5 million and 500,000, and then the status is ongoing. The closing month is June. The July status was also ongoing, and we're told that scoping has started, so work has begun on that project. The next one down immediately below it is another new one, NIDEC, new client implementation, and that has 750,000 and 350,000, is ongoing. Close month was August, and it's dated to be its July status, is therefore ongoing, and in that one, scoping has also started. And then we can miss out the next three, and then go on to the other two of the four contracts. So the first one in the amber or yellow is another new one, the BBC, re-implementation with BBC, and then you've got two figures, 2 million and 1 million. You've got, look along there, you've got the closed month is August, and the July status is said to be ongoing. And then if you look along there, project now includes worldwide, moved to HEC, RFP replied to decision at mid-August. Now, this is the strongest case of a misstatement of the position regarding the pipeline, because it was positively untrue to say that the position relating to the BBC was ongoing. A lot of our case, as you'll see when I read the other issue that follows this one, which is technically issue 1, a lot of our case was explained by reference to the documents. But if you want to know where the document is that actually shows that it wasn't ongoing for the BBC on the 24th of July, you've only got to look back to page 224. And if you look at 3 emails on that page from the bottom to the top, the bottom one is the 23rd of July at 12:54, sent by Chris Smith, the Sales and Marketing Director, to somebody associated with the BBC bid. And just a gentle reminder, we're going to share with me the costs that you put into the BBC proposal so that we could finalise our conversations about possible movement on our side. Middle of the page, someone comes back. Dear Chris, we've been informed we were not down selected for the next stage, due mainly to cost, but also due to the fact we weren't in the top 2 in response either. I think we'll need to debrief to understand how we should approach any future BPC bids. And Mr. Smith, unsurprisingly, says at the top of the page, not the news we're expecting or wanting to hear. So by the 23rd of July, BBC was no longer available. Simply, they weren't even in the shortlist of 2 to move on.
Just before you move on, Mr. Warwick,
Yeah.
if I knew what CRs means back at 239, I've forgotten. What was
It's shorthand for change request. my lord.
What does that mean?
That I'm not completely sure, my lord.
So that column we don't particularly need to worry about.
Yes,
do we?
I haven't focused on it.
No.
It's a variation.
I'm told it's a variation or enhancement to what had gone before.
So does that mean that the figure in the CR column is additional
Exactly.
to the previous figure?
But no, they are. I'll just double check this, but I
So
understand.
it's value and then it's extra because of a change. Next column, 500,000.
Yes, but you add the 2 together, so
Yep.
potentially we're talking about £3 million
Yep.
worth of work.
And can I just speak of that? These weren't the only. But these weren't the only 4 projects that were in the pipeline. All these projects in the pipeline, all the way down.
This is the entirety of
Of
the
the
pipeline, including, as you were rightly told by Mr. Lowe, established ones, which tend to be rather smaller in figure terms, which are all continuing projects. That's the first section, and then the second section.
So, for example, in the last section, the 2 at the bottom, or Jazz Pharmaceuticals and Clark's, were new projects which were ongoing, and would they also come within what you're going to say is the pipeline and therefore prospects?
Well, everything in the pipeline
Is
would
prospect.
feature as prospects, unless, of course, the prospect was 0, in which case, do you call something that's got no chance a prospect?
And you say BBC comes to that.
But we certainly say.
Okay, so everything else, all this is the pipeline, all this is prospects.
Yes.
And Mr. Warwick, I am ashamed to say, please could you remind me what the colours mean?
Well, that was a subject of deep contention at the trial.
Oh, I thought
No,
it was going to be a simple
it's
question.
It's right to say we contended that the traffic light system more or less reflected traffic lights. So red was stop. In other words, it was no go, and amber was in the works, and green was go.
Mm-hmm.
The defendants said no. Basically, they were all shades of grey. I'm not sure that somebody said that in terms, but that's the essence of what they were saying. They were all had differing probabilities, but nothing was that clear cut.
Thank you.
And there are, I could look it up, but there are some judicial findings on that. The other, so there's one more of the 4 that I need to take you to below the BBC one. So the second in the amber section. Kerry Group, and you look along there and you've got 1.5 million and then 1 million for the change request, and then you look along and that was delayed, further delays to the Kerry finance team's availability awaiting completion of year end, likely to engage October now. And then the other thing to note on this, because I'm only showing you this really specifically in relation to construction, so that because this is a document that was obviously part of the background. The grand total on here is just over £21.5 million, and that is an increase over the May pipeline of about £6 million. The May pipeline, just to remind you, is on page 217 of this bundle and has 15,243,000 as the grand total.
Was this document produced as a management tool generally, or only for the purposes of this or other transactions?
Well, that itself was the subject of contention at the trial. The two defendants both sought to downplay the significance of the document, and indeed their case was that there was very little document. Before they were looking to sell the business, there was very little, if any, documentation about the pipeline or prospects or things of that kind, and that documents were produced for the purposes of looking for a buyer. We didn't accept that that was the case. Mr. Smith, the marketing man, had come in earlier, and he was very keen on things like pipelines. So there was evidence about some existing pipeline documents, and you'll see when we get to another one of the issues, and I take you through a bit of the chronology, that there were pipeline documents in play before these.
Right. So it's not just the ones that we've been.
No,
taking to.
I'm focusing on these.
There was a string.
There were others, and I will be showing you a chronology that I prepared for the trial, because that's an easy way of showing you the history, because we've got the chronology in the bundle here, and all we've done is we've substituted the appeal bundle references for the trial bundle references, but otherwise it's exactly in the form that it was before.
How often were they produced on your case? Were they regularly produced, monthly, or
no,
on an ad hoc basis?
It was relatively ad hoc. They were very important to my clients, who were very concerned about knowing what the future prospects were. And that's partly probably why the judge made the findings that he did in the page I've asked you to look at under background. There was a great deal of evidence adduced as to Mr. Bell wanting to know what the future was. As you've seen, the decision companies, which are based in South Africa, they had no British business, and so they were interested in this, the defendants' company, because it would hopefully bring them another line of work in a different part of the world. And so it was wholly vital to my clients to know what the future held for the purposes of the business that they would be invited to pay many millions of pounds for. They weren't paying for the staff, because the staff were only there to service the business that came in. So there will be a few major projects, as you've seen the judge found, and those few major projects would then give you the insight as to what literally the prospects were of the business going forward. Anyway, I've shown you the July pipeline, and I won't shrink from saying that the document at page 239, the July pipeline, was the most important document in the case.
Well, I'm sorry to interrupt you.
Yeah.
It sounds as though it's very important to your case.
Yeah.
Were there any other documents between the May document of 217 and the July document of 2239?
Not of this ilk at all.
Right. So in other words,
there's quite a lot of emails and
in
queries.
terms of this type of pipeline document,
Yes.
with the commentary in the final column,
Yes.
to which you've drawn our attention, obviously, which you, with the BBC project, you particularly rely.
Yeah.
There was nothing like that between 217 and 239.
No. The next material document looking like a pipeline document after May is July, this one here, and there isn't another one until you get to the agreement. So,
did you explore it in the hearing how the evolution of the information about these projects? So, comparing and contrasting the BBC line in the 217 pipeline document and in the 239 document.
Oh, there was a lot of
variation.
There's a lot of evidence about what went on both internally and externally. Because this isn't a case of misrepresentation, whether honest or otherwise, yes. I'm not going to be beating the drum and advancing a misrepresentation case, because I would be otherwise falling into the trap that the judge said he didn't want to fall into. But true it is that underpinning this is my clients were misled, but the issue is not misrepresentation, it's whether there was a breach of warranty. And so we pinned and continue to pin our case now that the other parts have fallen away on the prospect warranty. So and after the July pipeline, there are a number of emails that you'll see helpfully summarised, or hopefully helpfully summarised in my little chronology. So hopefully I won't need to take you through lots and lots of documents. I can do it in a more simple case. But the extant pipeline was this one at 239. So it was a key document in terms of the background. Now, those are the four preliminary points. So then, what was the judge, how was the judge then approaching his exercise when it came to assessing prospects? Well, for that purpose, we need to go to the judgment, and we go to 126, paragraph 126, which is on page 60. If you start the introduction, it's on page 67 of the bundle, core bundle. And 125, you've got a reference to debate between Mr. Lowe and I as to what was meant by prospects. And you'll see Mr. Lowe advanced an argument as to what prospects meant, which I confess I never understood. And I'll be showing you what he's contending prospects does mean, but I'm still not sure I understand it. But anyway, he had an analysis for prospects. Mine was rather simpler. You'll see in the final sentence of page 67, I argued that everything came down to a single measure, the future profitability of the company. And just to add in that in brackets, that being itself dependent on the prospects of the company. Now, then how did the judge look at this? 126. Some truth in both of these. As with much of the case, it's impossible to lay down any abstract definition. It's necessary to approach the issue by interpreting the term in the context of the transaction. And so from my point of view, of my submissions, it's very important that I get across, whether successfully or not is another matter, but I get across that the judge was construing this particular warranty, this particular agreement against this particular background. And he says that's what he's doing in the context of this transaction. And the reason for the acquisition was to give decision a platform to build business in the UK. No doubt there were a number of factors which made the company attractive. These include the factors Mr. Lowe identifies, but the entire negotiation between the parties was based on EBITDA levels. It may well be the case decision would have been prepared to proceed with the transaction even if it had known that the earnings would drop significantly. But it's entirely clear that it would not have been prepared to proceed at the price level at which it agreed. Thus, other factors were of importance to the decision. It's the overriding primary factor was future gross profit. And so he then says, it's clear from the evidence that if anyone had asked decision what it considered the prospects of the company to be at any point prior to completion, or indeed thereafter, the resulting discussion would have been conducted in terms of expected levels of EBITDA. And we say that that is a wholly logical thing for the judge to have said against the background that he has himself set out earlier in his judgment. And what it does, so as I said, the pipeline documents are essentially the prospect documents. And it's wholly proper to ask that if there was a material adverse change to the prospects after the 31st of December 2017, but as at the 12th of October 2018, then that was contrary to the prospects of the business.
Now, just pausing there, does that quite fit how you put the case already? In the sense that you said, look, here are the pipeline documents. They show the prospects.
Yes.
And going off as a slight tangent, I think the notice and the pleadings refer to consulting services revenue, which again is sort of a reflection of the anticipated input.
Yeah.
Well, that's slightly different from gross profit, and it's different from EBITDA. So is prospects referring to anticipated consulting services revenue reflected in the pipeline documents, or is prospects referring to EBITDA?
Well, the prospects in the simplest sense were those, struggling to find an alternative word for prospects, but the future contracts that are listed out in the two pipeline documents, the that I've referred to.
And that I follow, but that's not quite what the judge said. He says we're worried about EBITDA.
Yes, because whether those contracts mature into reality has a direct impact upon EBITDA.
And I follow that, but it's still a different thing. There's a connection between the two, and I dare say quite a direct connection. But the way you put it so far, you say the pipeline documents are the prospects documents. That suggests that you should be looking at the pipeline documents, not EBITDA.
Well, certainly the judge looked at EBITDA for the purposes of calculating the loss that flowed on once he was satisfied there was a breach of warranty. But of course, his task would firstly be to work out what the warranty meant, and then to decide whether it had been complied with. And so he did go through that exercise. He did opine about what the prospects warranty meant, and then focusing on the 4 contracts, he then looked to see whether the description of the prospects was accurate or not, and he concluded it wasn't.
But here he seems to say, and tell me if I'm wrong, prospects means EBITDA.
Well, I'm not sure I'm necessarily, I'm sure I'm not parting company with the judge, but because what mattered in the end were the prospects that actually matured into real work. Because there are figures given on the pipeline document for what those particular outside companies would bring to the business, the value of the work. So the pipeline per se doesn't, I mean, it's no good listing 20 companies if none of them come to fruition. So what mattered was whether these companies would come to fruition in the sense that work would be brought to the company.
And I see that, but take the position in October 2018. Prospects presumably looks to the future.
Yes.
So if you had had a pipeline document in October 2018, you would have been looking at what was in that pipeline document, and that was taking into account the chances of those individual things coming to fruition. But that's rather different from EBITDA, isn't it?
Well, I don't think there's any inconsistency between what the judge says about 7 lines down in 126. The negotiation was based on EBITDA levels, because in that sense we're talking about the negotiation in terms of the negotiation towards the price. So you had various mechanisms as to monies to be paid initially with a breakdown. Some of them were quite complicated. You know, a certain amount of money paid up front, and then more money to follow, with a complicated chart depending on, in the future, on future work that would come through. Now, I'm not too keen to get enmeshed in all that, because that's not the warranty. We're not talking here about a warranty as to the position post the agreement, because the warranty was warranting the prospects. And the case that we were advancing was based on these pipeline documents. And those being prospects, and were they true prospects? Were they not true prospects? And the judge goes on to, and I'm not actually sure that the allegation of breach, which the judge posits, is challenged. I mean, the focus, as I perceive the appeal, is firstly, what does the warranty mean? Not then, was it breached, but what does it mean? If it meant what the judge said, then he was presumably right in finding it was breached. And then of course, there's the complaint about that it wasn't appreciated, what I call the natural justice point, because it's called that in a number of the authorities, wasn't appreciated by the defendants, that they were facing a case about the pipeline documents.
Can I just get back? Can I just get back to your challenge to Mr. Lowe's characterisation of what prospect means? He's saying it's a broader concept than simply the narrow concept. I mean, he's put it You're saying it's a more concrete thing
Yeah.
attached to the pipeline documents. And he's saying no, it's a broader thing, looking at wider factors. In what you said to us already, you said that your clients were interested in expanding into a part of the world where they hadn't got work before,
Yeah.
based in South Africa. I mean, doesn't that imply a broader idea of what they were looking for, what they were interested in, than simply the narrow question of whether the existing possible projects were going to come to fruition?
Well, one of the tests, I think, for any contractual term is it sufficiently certain to have meaning? And well, I mean, no disrespect to Mr. Lowe, but it is vital if you're going to give any view, which you will give a view, as to what the prospects warranty meant in the context of this agreement, to work out whether it was a term that could work, because giving a term a provision that is too vague or uncertain, you won't be able to test, and a warranty that you won't know whether it's breached or not is a meaningless warranty. So the conclusion to which the court comes has got to be one that has true meaning, in that you can then stand back and say, has it been breached or not? So looking at the prospects in terms of the pipeline documents against the background of this type of arrangement has logic to it.
I mean, earlier, I think your documents earlier talked in terms of consulting services revenue. So that would be a sufficiently certain meaning of prospects.
Well, that's essentially those figures that we've got in the pipeline. I mean,
Well,
consulting
yes
services
and no,
revenue
because you can't just take the gross figures. The anticipated consulting services revenue in October 2018 would not be adding up all these figures and coming to the gross figure. You'd have to take into account probabilities, surely.
Oh, indeed. And earlier pipelines did have references to probabilities, and then they got knocked out because it didn't serve the defendant's interest, we said, to be putting in percentages, because then that gave a picture that was not as rosy as it might do.
And I see that, but we're not dealing with a misrepresentation.
No.
But anyway, so if we were looking at consulting services revenue for the future in October 2018, you'd work out what would be in a pipeline document, were there to be one. You might take into account probabilities and so on.
Yeah.
But you would have an anticipated consulting services revenue for the next year or the next period or whatever.
Yeah.
And that would be a sufficiently certain meaning, perhaps.
Yeah.
But that's not what the judge does. He goes for EBITDA, which is different.
Well, except that when he comes to breach, he carefully looks at the 4 contracts and assesses what the prospects of those prospects were. And he has no difficulty including the prospect for BBC as nothing. And then the others, viewed objectively, because there were quite a lot of contemporaneous documents about this, he doesn't have difficulty in concluding that the way that there is a description for the 4 is in each case one that was objectively too much.
Now, plainly, that assessment would feed into an assessment of anticipated future EBITDA, and it would feed into an assessment of anticipated future consulting services revenue. But the fact that he has done that assessment doesn't help you on whether or not prospects refers to EBITDA.
Well, he certainly looks at the let's say the July pipeline for the purposes of evaluating whether there's been a breach or not, and he concludes that there has effectively been a breach in the 4 instances that I've identified in the pipeline document. He then needs to look at the EBITDA, because he needs to then work out how does that, what's the measure of loss, and there was more or less an agreed formula on the part of the experts as to how to do that.
Is that, not with respect, putting it the wrong way round? Because in 134, he says there would have been a material adverse change unless he had a high degree of confidence in relation to the 4 contracts. So here he's still working in EBITDA and he's saying, well, the EBITDA is going to come out worse unless the 4 contracts are going to work out.
Yeah.
So it's all feeding into EBITDA. It has nothing to do with consulting services revenue as such.
Well, the consulting services revenue is just a way of describing the figures that are on the chart on the pipeline.
And in your notice and in your pleadings, you do that.
Yeah.
But that's not EBITDA.
Well, the parties against the backdrop of the prospect documents, as I call them, are then negotiating figures, and they go up and down, and what proportion is to be paid initially, and then there's this complicated chart which is all to do with the subsequent income that comes into the company. But it's all worked on a basis that there was a flaw. No one was anticipating on our side that the prospects were as poor as they were. Although you're right to say that the judge is referring to the EBITDA, is he not doing that by reference to the particular contract? Because when he gets to working out what the actual figures are, he goes through each of the 4 contracts, beginning at paragraph 135.
And Mr. Warwick, you would say, therefore, I assume, that the judge used EBITDA because that was the measure which turns something intangible, being prospects, into something tangible,
Yeah.
that you can use as a measure. And he does that in relation to, at 134, by reference to the 4 contracts, because he's then looking at whether the effect that will have on future EBITDA, whether there will be a rebalance or not, and that depends on how confident one ought to have been, put it that way, in relation to the 4 contracts. And therefore, although he's, and I'm just asking whether this is how you're putting it, that although he's using EBITDA as the measure, he is looking at prospects in relation to those 4 contracts and how confident or otherwise one ought to have been in relation to them.
Well, he needs to evaluate the prospects because he's concerned in this part of the judgment with the prospects warrant.
Absolutely. But in your favour, I'm asking whether you're saying he's using EBITDA as the tangible measure, but in fact he is looking at prospects in the sense of how real are these contracts and are they coming in or not, in a prospects way at 134.
Well, my lady, if it's a point in my favour, I'm not going to be disowning it.
I'm obviously not describing it very well.
I suspect that your ladyship is articulating rather more clearly what I'm trying to, which is that the judge does, having worked out that you look at the background for the purposes of evaluating what the prospects warranty is, and the most important document is the July pipeline, then it has the 4 contracts, he then has to work out whether there's a breach, and then he has to then follow through and work out what the actual loss is as a result of that. And he does that in terms of EBITDA because that is the measure that the parties, it's common ground that we're using.
Well, that's what he says. The reason he uses EBITDA is because that's what the parties, specifically your clients,
Yes.
were working on. That's what he says at 130, for example.
Yes.
In describing what would have happened had they known the truth, he talks about the EBITDA.
And my clients were being entirely transparent. I mean, these discussions were taking place. We weren't holding anything back. We made it clear that we were really interested in the prospects of the company. I'm not sure it would really help you, but there is a lot of emails in which there's almost protest on the part of the defendants. Oh, well, he's coming back here. He wants to know more information about these particular contracts. So it's quite clear that we were interested in this.
you're probably coming on to this, and if so, just say so. But assume that prospects can be equated with EBITDA. It's common ground. You have to look at the position at the contract date.
Yeah.
Leave aside what other dates you might choose. You have to look at the position at the contract date and work out what the prospects are at that date.
Yeah.
If prospects means EBITDA, it must mean EBITDA for a future period, mustn't it?
Well, it's you need to know what the EBITDA was at the date of the agreement, and so that if that's an assessment of the money equivalent to the prospects, then you are standing on a particular date and you're saying what are the prospects as described essentially in the July pipeline.
Well, if it's prospects, surely you're looking to the future.
You are.
In which case, you're looking to a period after October 2018.
Yes, but there wasn't anything. I mean, it was a big part of the defendant's case to say that the further information that came into light that they knew about from late July up to the time of the agreement was all passed on to us. And of course, that was a major argument. There's a line in the judgment somewhere about how virtually all the cross-examination was directed to the pipeline. But that were unsuccessful in relation to that. So what we're doing is we've got a pipeline that isn't changed between the parties. So they don't write saying, here's another pipeline or change this figure to X. The pipeline was the latest statement of the prospect.
And I see that. But then why are you worried about EBITDA for January to September? That doesn't seem to have anything to do with prospects.
And why am I, well,
the judge has. He's taken EBITDA as it's October 2018, actual, to be EBITDA for January to December 2018. Well, why? Because if you're looking to the future, January to September doesn't come into it.
He recognises that there's another gloss on this, which perhaps I need to make, which is that although you've got a warranty for the period from January to October, the warranty isn't actionable if we have knowledge of the true position. So if it had been the case that we knew that one of the entries in the July pipeline was wrong, we've been told it was quite clear, then that's not any part of the, or it's no part of the prospects that was wrong. So it's like correcting it. So it is necessary to look back at the past to see what information had been given.
And I follow that argument, but that does it have any bearing on why you would look at January to September in assessing anticipated future EBITDA?
Well, I have to be careful that I don't start making submissions that reflect what I said as opposed to how the judge approached this. The judge certainly was aware that there were that information had come to us from earlier in the year that we then knew was incorrect. So it's not material to considering a claim for breach of warranty. And he said this as part of his permission to appeal judgment, that it's not right. So when he was dealing with his figures, if I find that passage, yes, this is a point that is on core bundle page 238. And it's the two paragraphs in the middle of page 238, which you were taken to by Mr. Lowe. And it's the second of those two paragraphs. Mr. Lowe raises the point the agreement provides the prospects of the excess of the date of the published accounts, and are therefore owed in considering developments after that date, where breach of warranty. I don't think that's correct. The warranty was effective with no material adverse change in the prospects, but the agreement also provided claimant could make no claim under a warranty in respect to any matter where the relevant facts had been disclosed. That's a sort of paraphrased.
Well,
Clause 10.
Mr. Lowe said it was wrong. Well, this was the point where I said, the lady corrected me gently yesterday afternoon because Mr. Lowe's point was that was an inaccurate paraphrase or summary of what was said in the agreement.
Well, it is a paraphrase of 10.7, rather, but it's not wrong. What it shows is that the judge was realising that it wouldn't be right to find that there'd been any kind of breach of a warranty when it was clear that information had come to my clients. So that although you've got a warranty spanning 9 months or so of the year, if in fact within that period the position is updated as it was in relation to prospects, then in order to do the assessment, you simply take the last available figure that was admittedly provided to my clients, which is July. So you don't need to look at the earlier position. You look at July. This is in fairness to the defendants. This is giving them the benefit of any doubt. And then you say, well, you've got July. Were the facts corrected post-July? Big issue in the case, but no, they were not. So you then say, well, look at July. That remained the prospects up to the making of the agreement. Was that warranty as to those prospects accurate or not? Now, you're probably going to come back at me and say, well, what about EBITDA?
I'll restrain myself, Mr. Warwick.
But since the part, it is legitimate to separate out the part of the judgment that deals with whether the warranty had been breached from the judge's then evaluation of what the loss was that flowed from that.
I know it's not helpful to interrupt you for slightly different points.
No,
But I'm still troubled about, perhaps we're going to come on to this, about interpreting the pipeline documents on which you obviously need to base your case as a reflection of prospects.
Yes.
And if we look at 239, and please tell me if you're going to come to this and I'll shut up. But the statements made, the comments made in bear in mind this is not a misrepresentation case. The comments made in the comment column focusing on the amber coloured lines, and they're quite vague in a number of respects, aren't they? Ongoing, several of them are ongoing discussions in progress made. How does that require sort of the sort of concrete quality which I think you're saying it does? I mean, isn't there an element of chance that the amber could turn green or the amber could turn red?
Well, until you actually get a signed contract, and strangely it was the defendant's evidence there never would be a signed contract anyway, but until you get a contract or a sum of money, then nothing is sure. And of course, even if you had a signed contract...
Are there signed? Would there be a contract in the Greens, or the Greens also? Would there be a contract with the Greens or not necessarily?
I think the answer to that is not necessarily, because I'm recalling the defendant's evidence, which is that these things, we said we'd like to see the contracts, and they said it doesn't work like that in business.
Okay. But would it be right to think that in all of these projects, and certainly the Amber project, some might come to fruition, some might not?
Yes.
Yeah.
But if you are to ask me what are the prospects of me being briefed in a case next week or in a
Very
month's
high.
time,
Although hopefully not next week because not much time to prepare.
No, but you might ask me, and I could give an estimate of the yes, this case, and if it does, then my client will hopefully extract a brief fee of X, and I'm giving my estimate of the prospects of that piece of work coming my way. Now, if it's a warranty, then I'm warranting that information is bona fide on the basis of the information I have available. As I understand it, the judge was testing the accuracy of all the 4 entries in here by reference objectively to all the extraneous facts. And there isn't an appeal against his finding, against his finding that if the judge was right as to his meaning of prospects, then he was wrong in finding there was a breach.
I mean, there is still another problem there, just reverting to my previous things, in the sense that what the judge does when he goes through these 4 contracts is says, well, you're not going to get the money in 2018. Now, if I said to you, Mr. Warwick, what are your prospects? You wouldn't necessarily focus merely on whether you were going to get the money in this year. You might look on a broader basis. So suppose the judge has not found, I dare say you would say he should have, if necessary, he should have found, but he hasn't found it wasn't coming in January. So why isn't that a factor to take into account in prospects?
Yes, I suspect that the example I gave to my lord is probably not perfect, because I was
It's quite interesting. It's quite an interesting example.
I was then talking about a case next week or next month, which is time critical. Your lordship is saying, well, no, these are not time critical, because they might come in a little bit later on. But the judge seems to have been alert to that and was saying, I'm standing back objectively and I'm coming to an assessment. And objectively, if you look at the pipeline document and you look that if it says, because I agree the word ongoing is vague, but it's not ongoing in the abstract. It's the whole line. So if you've got Kerry Group, you've got 2.5 million delayed. It's better to look at one of the others, like TFL. You've got 2 million there ongoing. So the judge was then evaluating objectively if you put that in a document. If this is a statement of prospects and you put that in, is that objectively correct?
But that isn't quite what the judge asks, because he says, look, I have to think about EBITDA for 2018. And that means I have to think about what the prospects are of these contracts producing money before the end of 2018.
Yeah.
And then he goes through and says, we're not going to produce money before the end of 2018. So he's only thinking about October to December. And it's not obvious why that should be right. I mean, even if you're thinking about EBITDA, well, why is it EBITDA for October to December?
Well, he in the judgment, he doesn't stop when he makes this assessment. I'm just having a look now. Because this is page 69 onwards.
And he says in 134, unless there was a high degree of confidence, very high degree of confidence, that profits over the next few months would be sufficient. And then that fits in with him going through saying, well, 142, 2018, 145, the year 2018, 149, in the course of calendar 2018. So he's not talking about what will happen in 2019.
Well, perhaps the clue is in 134, where he uses in the 5th line, rebalance the ship.
Because he says things haven't worked out well so far in 2018.
Yeah.
But that's historic. So if we're looking at prospects, shouldn't we be looking to the future?
Yes, and you look to the future and you say, will the ship, if the ship looks like it's sinking, then, but do we have sufficiently good prospects to rebalance the ship so that it doesn't sink? He doesn't, if we look at what he has to say, at the end of 137, when he's dealing with the BBC, I do not think that a hypothetical reasonable seller would have had a high degree of confidence that this contract will produce any significant turnover in the medium-term future. So he's not saying by a particular date.
But he is with the others.
Well, and then in... Yeah, would have been... I see, yes. Well, what that means is that this might be a critique, not of his finding of the meaning of prospects or prospects warranty, but that his findings here don't then support I don't know, it would be, there'd be a breach of the warranty, but it wouldn't be quite as an extensive a breach as he found.
Well, what he must be construing prospects to mean EBITDA for the current calendar year, even though 3/4 of it has passed.
Well, it's not for me to say what.
That's how he measured prospects, isn't it? That's how he measured prospects in this case.
What he's doing is, as my Lord has correctly pointed out, in relation to the BBC, he's looking into the medium term. So he hasn't got a cut-off for a particular year. In relation to the other three, he's estimating, expressing a view up to the end of the year. But since we are here concerned with prospects, does that matter? If the document as to prospects is here, he's asking himself, well, would the objective person in the possession of this conclude that this particular estimate of future work is wrong? And he concludes that it was wrong.
It's interesting in the where we've lighted on paragraph 137 that there he records Mr. Garbett's evidence, which fits with a broader interpretation of what prospects mean. For example, I want to go back to the question. I will avoid going back to the question of your next brief, Mr. Warwick. But we've all had the experience of not getting the brief at the bar, but hoping that as a result of the conversations that we had, we will get the next one from that client. Sometimes it happens, sometimes it doesn't. Mr. Garbett's evidence was that discussions with the BBC were such that although that project came to nothing, he hoped it would. And the judge said, I'm sure he did hope that. Why isn't that relevant to the assessment of prospects? Why is prospects so narrowly defined to the concrete and the here and now?
Well,
Not what the word means in normal life.
Well, the focus was you've got the prospects warranty, whatever it means, and then you've got what the breaches were, and the breaches are in relation to 4. We weren't focusing on anything else, so we're not saying that the prospects warranty means they were just warranting for these 4. We're saying that this was a warrant as to the material that was on the sheet. But it just happens that we were able to focus on 4, which were very important 4. They're covered a lot in the documentation. That we were able to show the judge, and he was so satisfied that that was that warranty as to prospects was wrong. As to at what point you look at the future, and the point being made about looking into the future, if you look at page 48 of the core bundle, paragraph 22 of the judgment, there's a reference here to Mr. Garbett, and this maybe your lordship had in mind.
Yes.
About halfway through 22, Mr. Garbett said in evidence there was considerable value in the company in the form of its installed base, in the form of its assembled team of experts and consultants. Mr. Pimpstein and Mr. Bell, who were my witnesses, were adamant that this had very little value to them unless accompanied by a sufficient flow of new business. Hence, the expected future profitability seems to have occupied the majority of the attention of both sides during the negotiation. So the team was in place, and this is addressed under background. It was very expensive to have a team. So that's why it was so important to have this pipeline of people coming through so that the team could work on it. Otherwise, the ship, once it starts to tilt, goes down quickly. And so it's right that you can look at the future, but that isn't going to right the ship if the 4 major contracts that we potential contracts that we're looking at aren't of the kind as described in the pipeline. My Lord just now talked about what the meaning of prospects might be, not my meaning or not the judge's meaning, but the defendant's meaning. Can I take you to what is put forward in the defendant's skeleton as being their meaning of this? It's in the core bundle at page 257. And it's paragraph 22.3. Above that, there's a critique of what prospects wasn't. And then 22.3, the better view is the intended meaning was as contended for by the defendants, concerned with the fundamentals, the company's ability and capacity to fulfill work, and its reputation and standing generally, rather than the existence of the work and its fortunes in securing it, which are variable. And so the fundamentals of the business and the ability and capacity to fulfill work and reputation. Now, if you take those words and put them in place of the word prospects in the agreement, how would it be possible for anyone to know whether that warranty, which is a contractual obligation, has been performed or not? We say the normal meaning of prospects is that the chances of particular, I think the Lord Justice Newey said this yesterday, the chances of something happening in the future. Not all these other things that are down here. It's real work. This is not some ethereal debate that the prospective seller and buyer are having. It's does the company get sold? And it's only going to get sold for any money, or certainly any substantial money, if it will survive and it will bring money in.
So in assessing the chances, the future chances, wouldn't you take into account the sort of evidence that Mr. Garbett gave in that's quoted 137? We didn't get the BBC product on the last occasion, but I've got a really good relationship with X, Y, and Z at the BBC. The BBC is an international organisation. It represents a new line of work for us beyond financial services, etc., etc. And I'm pretty confident we're going to get some more, even though we fell short this time. Wouldn't that be relevant? Isn't that relevant to the assessment of chances?
Well, a difficulty that's here is that, of course, that wasn't the defendant's evidence. The defendant's evidence is, look, we've secured the BBC.
Yes, well, that goes to real breach point.
Yes. But my problem is, if you don't like what I've had to say or what the judge had to say, and you come up with some other meaning of prospects, it must be right that you look at that in the light of the background of the particular contract. That's elementary. And so how do you come up with your definition that's workable in a commercial sense? And we suggest that the defendant's definition isn't workable.
And I do absolutely see the force of this submission. At an earlier stage, you seem to pin your colours, or your side seem to pin their colours, to the mast of consulting services revenue. I mean, that would be more workable.
Yes, well, but that consulting services revenue is just the word for fees, or the money that comes in from particular customers.
So you could say, you look, or whatever the right date is, and you try to work out what consulting services revenue could be expected in the future period.
Yes.
And that could be the prospects.
Yes, and isn't...
So that's not what the judge did.
Well, isn't that what the July document is doing? It's giving real figures for value, not a percentage, so it's not giving a probability. It's giving real figures, and then it's giving a comment about it.
But no one's warranting this document. So you would have objectively, come October 2018, to work out, presumably by reference to these sorts of prospects, what consulting services revenue you could expect in the future, over a year or some other period, I don't know. I agree, even that stuff far from well defined. But I can see why you went for consulting services revenue earlier on, and then you would look at the position in October. This document of itself wouldn't matter, but it would be a doubt to something you took into account evidentially in working out what the prospects were for the next period.
Yes. And we had May, and then we had July looking rosier, at least in terms of the total's gone up by 6 million. We're being presented with material about this company's prospects that makes it worth our while continuing with the negotiation.
And I see that, and I can sort of see why you might be aggrieved. But as you say, it's a warranty claim. So on the face of it, you look at what anticipated on this theory consulting services revenue would be post-October and what it might be post-January.
Yeah.
And that is not what the judge did.
Well, I'm at risk of repeating what I said, that his use of EBITDA seems to be to calculate what the loss was flowing on from the breach of the warranty. But he did make findings about the particular warranties, which are the ones I've taken you to, which you know, he goes through each of the four companies and gives a view about it. And he doesn't necessarily say in each case it's exactly the same date, but he is doing his best to assess what the prospects were. And I say the curious thing is I don't perceive that all these parts of the judgment are subject to challenge, and the only challenge that's made as to quantum is the little argument that we get to under ground 4. Otherwise, there was a great deal of common ground between the experts about how you would approach this, because it was all being done, calculations being done under EBITDA with whatever it's 6.43 multiplier and all that. So it was possible to use figures and plug them in. Yeah. Now, yes, I think I'm just looking at my notes. I think I've taken you to because this is an argument about construction and not the rest. I don't want to overflow one issue into the next. Those really are my submissions.
Yes.
And it is possible to see why the judge arrived at the conclusions he did, bearing in mind his statement as to what was the background to this particular agreement. And not that I'm writing your lordship's or ladyship's judgment, but I would be inviting you to stress that when you approach a prospect's warranty, that you do so in the context. This is obvious. In the context of the particular background that led up to the agreement in question.
Yes.
Now that's was ground 2, but it doesn't really matter what the numbers are. The next ground is framed by the question: was the judge's decision a breach of natural justice? That's how it is. Can I make a few basic introductory points? The issues before the judge were relatively straightforward. That's his phrase that he uses in paragraph 84. And we say that the defendant's appeal in relation to this point is over-sophisticated. And most importantly, we say that the test now to be applied when considering a ground of appeal like this is Ali and Dinch. I understand, having spoken to counsel in the case, it's Dinch and not Dinch. Lord Justice Baker queried yesterday as to whether perhaps there'd been a broader approach introduced in that case from what you find in some of the earlier cases. And I would answer yes to that. And my resistance legally to this ground is based principally on Ali and Dinch, obviously a Court of Appeal decision, supplemented by the Supreme Court case, which you know all about. And now, if I can go to the bundle of authorities and look at Alley and Dinch, there's some reference on the part of Lord Justice Burst to authorities, some of which you saw, the Allen in any case, and so I'm not going to go into any of that. And I go straight to page 400. To emphasise one or two parts of 25 and 26. So he said, to these statements of principle, I wish only to add the following. These problems are all concerned with the interests of justice, and in particular with circumstances which are called prejudice to the losing party. Common sort of prejudice, which is to be avoided, is the new point has arisen in such a way that the losing party was not given a proper chance to call evidence or ask questions which could have addressed it. That is why the function performed by pleadings, list of issues, and so on, which is to give notice of and define the issues, is an important one. It's also why a judge can always permit a departure from a formally defined case where it's just to do so. It's also why the judge's function is to try the issues the parties have raised, rather than reach a conclusion on the basis of a theory which never formed part of either party's case. And then you get to why I say the law's moved on a bit. By placing the emphasis on prejudice, the point I'm making is that the modern approach to the definition of the issues requires judges to adopt a pragmatic approach in line with the overriding objective and not to be governed by unnecessary formality, provided always that it's just not to do so. And I take that to be to backing away from some kind of strict adherence to the pleadings. There are comments made in earlier cases in which it's all about, well, can the case fall square within the pleadings? That's not the test. And then you get what is the question to be asked on this issue in 26. To decide this appeal, and we say therefore to decide the current appeal, the task will be first to identify what case or cases the parties were advancing, second to compare that with the decision the judge made, and third, if need be, to identify what prejudice, if any, may have been caused to the defendants. So this is not a question of what the pleadings say, full stop, end of the story. It's a much wider exercise that we have. And in relation to this question about evidence, what we're talking about here is not a decision on some factual point, because this is why when I was responding, preparing the skeleton, thought logical you have to deal with construction first, because this is an exercise on the part of the judge as to how to decide prospects. So it was a question of construction that the judge had to decide. This isn't one of these cases where there's some new factual theory about a third man or something of that kind. This is a judge making a decision on construction, which it's then said was new and wrong and unfair.
I mean, the question possibly is not so much the point of construction as of itself, but whether once you've decided on that construction, other issues arise that were not focused on. And once you've decided that you have to compare your baseline figure from October 18 with the actual figure from 2018 in relation to EBITDA, you're opening up new topics for discussion, aren't you?
Well, it's not as though the parties did not know that this was an issue. It was flagged up as a central issue in the case. It's one of the issues in the statement of issues. So,
sorry, which was one of the statements in the statement of issues?
Well, the best thing for me to do is to actually
there at the back of the judgment.
But yeah, find it at the back of the judgment. I think it's 3, isn't it? No, it's 1. Did the word prospects refer to the future financial performance or forecast of the company? And the answer was yes.
But that leads on to 3.
Yes. Material adverse change in the prospect. So the parties had come along to address those issues. And although I've developed this a little while down the lane, what one asks would have happened in this case, because it's necessary to do so. This isn't like one of the cases where counsel was able to say, I would have called Mr. X and Mr. Y, and I would have recalled Mr. Z. No one's been identified as being a missing witness who would have helped with this issue. And equally, I suggest that there wouldn't have been extra questions to be asked in relation to this. I've now found the reference that I had missed a little earlier on about the questioning over the prospects, and it's page 56 of the core bundle, the beginning of paragraph 70. The majority of Mr. Bell's cross-examination, unsurprisingly, related to what he knew of the prospects of 4 contracts, and then there's reference more to exploration of prospects. So there were something like 4 days of lay evidence plus some expert evidence here, and we haven't got that many documents. I mean, there were obviously a few more documents in the trial bundles, but they've been distilled down. The documents were very thoroughly investigated. There was questioning of the witnesses that was very thorough, and as I'm sure you've picked up, Mr. Lowe is a very thorough man. So there was, you can see, the majority of the cross-examination was taken up with dealing with prospects. And so far as the judge, what was he to do? And as we've seen, and Mr. Lowe fairly took you to this, there was an interchange between the judge and him in the course of closing, and it's SB 173. Probably got a marker in there. You remember the judge asks him about EBITDA and things like that, and it was addressed by Mr. Lowe. Of course, Mr. Lowe doesn't know at that point what the judge is going to decide, but then generally judges don't in closing. I think I've never had a judge say, Mr. Warwick, I'm going to decide the case this way. What do you think? I mean, the exercise is far more subtle than that. And so the judge was teasing out with Mr. Lowe, giving him an opportunity to respond, which he took up and said, no, that's not right. So this case, if this is the judge asking for help about construction of the prospects warranty, isn't this rather like Sarah and Black's?
It says that there are the 2 stages on there. You decide whether prospects refers to EBITDA, and I follow the judge raised that with Mr. Lowe. But that's only the starting point, because you then find the judge saying, not I'm looking at the position at December 2017 by reference to anticipated EBITDA, and I'm looking at the position at October 2018 by reference to anticipated EBITDA. I'm not sure he looks at anticipated EBITDA for either date, but at any rate, that's not put to Mr. Lowe, and there might be a lot to say about that.
Well, this is why the formulation of the test is rather more elastic, I suggest, than it might have hitherto been. And looking at the earlier cases, unless you want to, the third man or something as an extreme example, but we are not, I respectfully suggest, even if you're against me, we are not some kind of extreme example here. We're into territory of judges who have to make decisions on a set of issues, and it's suggested they do make a decision, but that there wasn't sufficient opportunity given to counsel. Now, there are judges, I've met them myself, who, after they've gone away to write a judgment, you then get a note saying, sometimes I found such and such a case, or sometimes the judge even rings you up. I once had Lord Justice Hoffman ring me and say, I found all these cases.
We don't do that anymore.
But that isn't pertinent in this case, because it's not the judge coming up with lots of cases that he should have given the parties an opportunity to address him on. He's simply resolving an issue in a way that he concluded wasn't the same way as either party was advancing. But
it wasn't pleaded. It wasn't argued.
Well, it's his resolution of what that issue meant. So if you ask and apply this test here, which is what were the parties advancing? Well, we know what the parties were advancing because we've seen the pleadings in this case.
Well, what are you reading from there?
No, I'm still looking at 26 in Alley and Dinch. Page 400 of the authority. So, what case or cases the parties advancing? Compare that with the decision the judge made, and if need be, to identify what prejudice. So, if the judge's decision is within the territory, I think your lordship used this phrase, or you used something analogous to it yesterday. If it's within
known parameters.
the parameters, yes. So, if that's the test, then we say the judge's decision was within the parameters. And the defendants here have to show that it was outside the parameters, and then it's necessary for the defendants to show why they're prejudiced. And I'm sure that Mr. Lowe would have found something to say if he'd received this in the draft judgment and had been invited to make some submissions. But that isn't the same test. It's opposing to harsher tests on judges. That a decision here in favour of the defendants on this ground will, I always hesitate to use inter rorem submissions, but might send concern amongst those lesser levels on the bench that what are they, when we heard submissions A and B, got to be very careful that, when I make my decision that it's very strictly stuck to what the pleadings say, and there's a careful line here, and these are just my initial submissions, that we're on the right side of the line so far as the judge's conduct. And obviously here, I am supporting the judge and saying he's right and you shouldn't get another way. And there is a comment made in the judge's, of course, just find the reference. Yes, it's the Commission to Appeal judgment. Again, it's Corban, page 237. Can I take you to the top of page 237? It's the paragraph there. And it's Mr. Lowe's first ground is the prospect's claim was inadequately pleaded. My approach to any pleading point is it's only a good point if it can be shown the result of the way the case was pleaded led to the other side being disadvantaged or surprised at trial by an issue wasn't raised in the pleadings of the other side. This was clearly not the case here. It's entirely clear in the pleadings that one of the points that would be taken would be the prospect's warranty, and the substantive dispute between the parties was precisely what the prospects were in fact expected to be at the time when the warranty was given. That point was the primary issue at trial. And so, in the end, says it could be pleaded differently with the conduct of any different. So, he is answering the question that I posed a little earlier on about what would have happened at the trial. And I say no different witnesses, no different questioning. And so the highest it's put is counsel may have wanted to say more than the opportunity that was given in the course of closing. And that we say, I won't say it's a counsel of perfection, but that's expecting too much in the context of this case.
So do you say then that what Lord Justice Burst said on the facts of Alley and Dinch, in concluding at paragraph 34 of page 403 of the authority's bundle, that could be cut and pasted into our judgments?
Indeed, and if you had my skeleton by email, then you probably would literally do that.
That's what we actually do. It says that it wasn't, the judge's conclusion was an intermediate combination. That's the phrase you quote, isn't it?
Yes. Yeah.
Intermediate combination of various factual assertions made by. And of course, he goes on in that paragraph. You say all that would apply here.
Yeah. Yeah. That's why this case is important. And the way, of course, courts work is they don't tend to work by revolution. They work by a process of evolution. But I sense a slight, in order to address the point on which permission was granted in Dinch, because at first blush you've got somebody saying that's not my case. I mean, the defendants are not able to say, oh, well, I disowned this case. I mean, their case is the judge decided it on a different basis from the one I submitted. But that's a commonplace. So our case is easier to decide in my favour because there's no suggestion I disowned the judge's thinking. Now, those, I have to say, I'm sorry, I've taken a little bit longer than I'd surmised, but they were my introductory comments. I was then going to look at the various elements of the case to show there's been no breach of natural justice. I'm going to canter through this. Some of it you've seen, so I will literally go very speedily. But there's a few documents that are part of the history that I wanted you to see, get a bigger picture. So this is the case and the different steps that were taken. So breaking it down almost as though this was a CMC or something. What are the different steps that were taken? So you've got the pleadings. Well, I don't need to show you the particulars of claim because you've seen that. So there's the particulars of claim paragraphs that you were shown. And of course, they cross-refer to the main pipeline documents. I can't now remember whether they were even annexed as part of the particulars of claim that they were. Yeah, no, the agreement and the notice was annexed, but not the pipeline documents were expressly referred to, of course. So they were in play, and then there's a defence. I'll let a friend show you, and then there's a reply.
I mean, I follow that they were referred to, but they weren't referred to in this way. The case you were putting more obviously fits the wording of the clause. You say paragraph 11, and this of course reflects the notice. Prospects refers to the future financial performance. So far, so good. So it's looking to the future, not to past EBITDA. And then paragraph 12, the prospects were represented in the pipeline document. So you say, well, look at the pipeline documents for the prospects. And you say, had the correct position been represented, then consulting services revenue for 2018 would have been 3.5 million. It represents a decrease from consulting services revenue in 2017. So, yes, the pipeline documents are referred to. The focus is on consulting services revenue, and you're comparing 2017 with 2018, which is not what the judge does.
Yes, I accept that, but this is the part. There aren't lots of documents that are referred to in the particulars of claim. Clearly, the pipeline documents were centre stage, but I agree, not pleaded out in the way that the judge found. After the defence, there's then the reply and defence to counterclaim, and there's about 4 paragraphs I wanted to show you in relation to that. You can go straight to page 147. Paragraph 27 on page 147. I'm dealing here with a paragraph in the defence, which is when they're pleading out what they say the warranty means. And then I refer to 3 lines down. It's inconsistent with the structure of the agreement to contain an express warranty as to prospects. And little a, it's agreed that the company's revenue depended upon pitching to clients and procuring commitments from them as to the retainer of the company. Defendants were able to and did categorise the nature of such commitments in pipeline documents, see below, and the first claimant placed reliance on those documents. And then over the page, at little b on page 148, say about comment is noted, not relevant to this claim, which is based on prospects as described in the document. Those prospects were subject to an explicit warranty. Defendants well understood how important the prospects were to the first claimant, as the first claimant told them so. Defendants' own documents reveal the defendants appreciated how important the documents as the prospects were to the first claimant. Then there's a reference to an email, which you'll see, I won't read out, which is an internal email about what the prospects were.
So the prospects are described in documents, presumably the pipeline documents,
Yes.
which is not EBITDA.
And then over the page at 149, paragraph 31, in answer to one of the ladyship's questions, they say it was just the level of confidence. And if you look at the end of 31, the colour coding didn't purport to reflect a level of confidence. It was a statement as to the status of the opportunity that was listed. And then 38, I should go back to the defence so I tell you correctly what this is dealing with. Yes, this is dealing with paragraph 10.2 of the defence at page 118. They're talking about the first claimant had actual knowledge of the revenues. And we say at 38 on page 150, documents provided to the first claimant included statements of the company's prospects on which the first claimant relied. If the defendants are alleging the first claimant had actual knowledge, then that's denied. And then at 41 on the same page, as the second sentence of paragraph 31, the word prospects is a reference to the defendant's then present-day assessment of the opportunities that were listed. Some of these prospects in green are secured and were ongoing, others in yellow were potential, often with a description of the likelihood, the remainder of so-and-so is pleaded. So this paragraph here, prospects, is a reference to the present-day assessment of the opportunities that are listed, is really flagging up the point that I've been addressing this morning. Now, so that's the pleadings phase. Then, moving on, we get to the trial. And so there's a skeleton from myself. I can just take you to supplementary bundle, page 59. So here's the skeleton. 59, introduction. It's concerned with an agreement. First claimant agreed to buy the shares. Then there's a reference to financial planning. About 90% of its annual revenue was generated from consultancy services, the remaining 10% from support services. It's common ground that as a services business, its value lay in its ability to deliver future profits rather than by reference to its assets. And there's a reference then to the defendant's expert having agreed that. In the course of negotiations resulting in the agreement, the two defendants, who were the company's two directors and its sole shareholders, provided various documents, including documents referred to the company's business in the pipeline. Some of the documents were actually termed pipeline documents. The agreement was then made, it provided warranties. And then at paragraph 8, I refer to a chronology, and then at the bottom of paragraph 10, I refer to a pipeline forecast, and then skipping over here, paragraphs 12, 13, and 15 all mention pipelines. Paragraph 16 mentions pipelines, 17 pipelines, 19 pipelines, and then 21's pipelines, and then there's reference to emails, and then 29's got pipelines, and then I think I'll stop there because then we get into the making of the agreement. Now, also provided to the parties and the judge was the trial chronology that I prepared. That begins at page 90 of this bundle, and as I explained a little while ago, this is the original chronology. All that's been done is the final columns have been changed to give you reference to documents that are in the supplemental bundle. But I can save, unless we have to, I'm not going to go to those documents. So going back to 2017, you've got the first defendant emailing his marketing director, Mr. Smith. I believe you have a screenshot of the pipeline forecast. Any chance I have a copy? And then Mr. Smith comes back with the current opportunity pipeline. So in answering a question from Lord Justice Baker, this is the first track we have. And obviously disclosure wouldn't exceed that because this was when the first steps are being taken to for the company to be sold. And then over the page, you've got 3rd of January, there's a first draft of the sales pipeline. 10th of January, an updated pipeline. 26th of March, there's a reference to a sales pipeline. And then 29th of March, at the bottom of page 91, please find attached the updated sales pipeline with some commentary from the team. As you will notice, the pipeline of opportunities and visibility of earnings are pretty strong. And then 27th of May is the updated sales pipeline. And then the second defendant comes back on the 28th of May. Have you updated the pipeline? And then 31st of May is when we get the May pipeline. And then there's references to various emails, which I won't read out, which include references to pipelines. And then if you get to the 24th of July, on page 94, the 3rd entry down, Mr. Bell emails the defendants and said, we need to get the documentation out before the meeting. Are all of those projects that I referred to on track with the revenue plan? And then the answer that comes back on the 24th of July, second line, yes, as previously discussed, those projects have started and are progressing. The judge had something to say about that, but that was the answer that was given. And then we've got another email relating to the project, and then a request for an updated pipeline at the top of page 95. And then we get, on the 24th of July, the July sales pipeline comes through, which I've shown you. And then I was asked about references to prospects. If you look at the 26th of July, there's an internal email from the managing principal consultant of the company to Mr. Smith, the marketing manager. With the BBC off the table and TfL continuing to drag its heels, are there any other prospects that I can help with?
Sorry, where are you looking?
So, page 95, my lord.
Yes.
26th
Oh, I
of
see,
July.
yes. Yes,
Sorry,
got
I've gone rather
yes.
quickly.
I've got that. Yep.
So that was just after, that email was actually 2 days after the July pipeline had been sent through. So those were, if you're interested in the sort of evidence that there was as to the inaccuracy of the pipeline, I'll just take you to the bottom of page 97. This is after the agreement. 24th of October, Mr. Smith sends an email to the first defendant. Let's talk about, there's going to be a discussion about the pipeline. I'm really struggling with this. It doesn't present the reality of the situation. I'll take a couple of examples. TfL is not worth £1.5 million, as I stated. The real figure is 850. NIDEX definitely not going to close in November for the big project. Kerry's not going to happen in October. I would have thought now that we're past the sales of Copperman, we need to present a realistic picture of where we are. If we don't, I'll be asked some very difficult questions at the end of November, why these deals didn't close, etc. So that just gives you a little of the flavour of what the factual background of the case was. So that was the start of the trial. Then the principal witness for my clients was Mr. Bell, and we've got his witness statement at page 7 of the supplemental bundle. And he deals, as you might imagine, with the whole history. So the whole statement is pertinent, and he deals with pipeline documents, and that's what I should do by way of emphasis, is if I go on to bottom of page 15.
Sorry, page number again, Mr.
15, sorry.
15.
15.
Thank you.
Further discussions which led on the 31st of May to being provided with a spreadsheet.
I'm sorry, I'm on page 15, but I am lost.
Oh, right. Because I'm terribly sorry.
Which paragraph?
Paragraph 30, my lady.
Thank you, I'm so sorry. Yes?
Which line?
Beginning of 30, my lord.
Yes.
Further discussions which led on the 31st of May was being provided with a spreadsheet. And then there's a breakdown of what the spreadsheet composed. And little c on the top of page 60 is the May sales pipeline. And then on page 16, still paragraph 32, he says that the May sales pipeline was key in showing how well Copperman was doing. Then there's the evidence that he gave about the traffic light colours. And then page 18, paragraph 39, 3 lines down, Stephen sent through, and that's the first defendant, the sales pipeline for July. And then there's reference to the 4 contracts, or the 4 parties, as it were, there. And then there's more evidence in this witness statement as to what happened thereafter. So Mr. Bell was the principal witness. He was cross-examined at length by the learned friend, and then so I've already shown you paragraph 70 of the judgment, which is the judge referring to the majority of Mr. Lowe's evidence for cross-examination being about prospects, and of course the defendants were cross-examined about the prospect documents. And then we're then up to closing, which I told you about, and the judge's own analysis of the documents. And looking at that, and I've really laid out my stall already in my introductory comments, it was sufficient material before the judge for him to properly come to the conclusion that he did without offending the rules of natural justice, the test as now set out.
Can I be unfair? Take you to your written closing. This is page 131 in the file, and it mirrors what you said orally, I think.
Yes.
And you say the issue calls for a comparison between the company at 2 points: accounts date and first completion date. You say the prospects can be shown in a number of ways, and you refer to certain documents. And then that, as regards the first completion date, the prospects will be for the court to assess. And this is quite different from what the judge has found.
Well, I've sought to stand as a sort of surrogate for his lordship in what I've said, in particular by explaining that he was cognizant of the fact that it wouldn't be pertinent to use against the defendants any information about prospects that was provided to my clients. So it's logical that the real focus is on the July pipeline.
I mean, of course, aside from points about meaning of disclosed and all that, suppose the prospects had looked pretty bad in December, and then they got better in 2018.
Yeah.
You'd known that some of what was being said in 2018 was wrong.
Yeah.
And then you get to the October 2018 position. Merely factoring knowledge would not be the right approach, would it? You'd have to start by asking what the position was at the end of 2017, compare that with the position in October 2018, and then potentially take into account knowledge to knock out some of that. But the starting point has to be December 2017.
Well, Mr. Lowe was very alert to arguing his corner in relation to what breach, if any, there was of the prospects warranty, and he produced charts and lots of other information to the judge. So it was quite a broad, the arguments about meaning of prospects and the like were not all over in a hurry. I mean, a lot of attention was directed to this. It's just that the particular finding that the judge made, conclusion that the judge came to, because his findings don't seem to be impugned, conclusion wasn't all square with either party's submissions.
And just to follow on point, suppose the answer is that in terms of the meaning of the clause, you have to look at future prospects as of December 2017. In this context, whether it be anticipated future EBITDA or anticipated future consulting revenue, or whatever. Was the judge in a position to arrive at any determination on that?
Well, he was presented with some evidence about what was happening after October 2018.
No, sorry, we're in December 2017. So,
Yes.
as you say here, as at the account state, the prospects, and then you refer to various documents. So whether by reference to those documents or otherwise, what could the judge have concluded that the prospects were at December 2017?
Well, he could make an analysis and work out, decide what the figures were.
And what would the answer be?
Well,
in
if he
terms
was
of
going back to that, then he would have presumably been looking at earlier pipeline documents, because there was one in January, and so he could have done that. In fact, if I find the...
Do we have that? 189. The January pipeline document?
I'm told it's 189.
It'll be in small type.
Yeah, I'm afraid this...
I'm not sure it is. It might be 121.
I mean, going from my memory.
No, I think I take it back.
188 is the covering email.
Yeah, it's 189.
It is 189.
And then 189.
I see, yes. Yep.
And that's got just over 12 million.
Did this exist in colour-coded version in the original? Mine is black and white.
Yes, no, I'm pretty sure this was black and white, and the reason is because later on a decision is made by the defendant to introduce colour. Page 201, you've got Mr. Garbett saying to somebody internal, no, the lady who was the selling agent, have a look at the attached. I've tweaked Anis's version. He's the second defendant, so it now has more colour and it's a little simpler. So I'm pretty sure that it was black and white when it was in January.
So if the judge had been looking at the position in terms of anticipated future projects at December 2017, he might have started with this document, which showed a total of 12 million odd, and obviously some of it was not certain, so you'd have had to take into account probabilities of those prospects materialising. At this stage, you haven't got NIDEC, you haven't got TfL, you've only got BBC and Kerry.
You had got Ladbrokes.
You have got Ladbrokes. But you would then have had to compare this with something later in the year. But we've got no clue as to what the judge might have made of all that.
Well, we obviously what we have is the judgment. So.
But he's never attempted to work out what the prospects were at December 2017.
Well, the material, and this comes to my last point on this ground, the material was available because the chronology that I've shown you that starts at page 90, you've actually got, if you need to look at them, all the documents, even in the supplementary bundle, but there were these plus even more in the trial bundle. So there wasn't, the judge had available everything from the pipeline forecast that goes back to page 176, I see. So, page 17. There's a document from October 2017, which is page 178. And that I seem to recall, if Paul looks at that, that's actually tolerably easy to read. And that is a Copperman document, is a copyright insignia in the bottom left-hand corner, and it's got a number of accounts named, and it's even got a whatever those circular charts are, pie charts with prospects. Anyway, sorry, that was answering your
Yes, thank you.
question. Now, my final point of this, on this point, is a postscript, essentially. What if the conclusion of the court is there's been a breach of natural justice here? What should happen? And reluctantly, I submit that there would need to be a retrial. Obviously, it depends on the nature of the issues, but there are at least two of the cases that we've got in our bundle in which the court decides that that is the course that has to be followed. If I can just show you the references to those.
So this is if we allow the appeal on ground 2 alone.
Yeah.
Well, ground 1 alone.
Great.
The one you've taken second.
Yeah, the one I've taken second. Anyway,
The natural justice.
The natural justice point, yes.
Actually, would it not? Getting muddled on my grounds. Suppose we thought the judge had construed the contract wrongly.
Yeah.
Then you would never have had your arguments actually determined,
No.
you might say.
Yeah.
Because those arguments were not the ones put. So it's not just ground 2.
No,
it's,
no.
yes.
I put the postscript in at this point, but I could put it in at
Yes.
off the other ground. The Satyam case, which is page 354, just to set the scene for this, this was the case where there was a finding that properties were held on trust. And if you go to page 354, paragraph 36, the present case is not one of the parties seeking to depart from this pleaded case, but one where the parties addressed in their evidence and submissions the cases that have been pleaded, but the judge decided the case on a basis that had neither been pleaded nor canvassed. And then they talk about the system of civil litigation. So that's the background to that. And then what happens is dealt with at the end of the judgments. So if you go on to 362, this is the end of the primary judgment, which is delivered by Lord Justice Newey, page 362, paragraph 73, under disposal. It follows, if my lords agree with me, that the appeal against the judge's primary basis for dismissing a claim should be allowed on ground 1, but it's not possible to determine whether the judge's secondary basis for dismissing the claim is allowed or not. In those circumstances, we have no choice but to remit the case to the High Court for a further hearing to resolve the matters, and they suggest it be a different judge. And then the Lord Justice Arnold agrees. Lord Justice Lewison adds at paragraph 81, it is doubly regrettable that the judge decided the case on an unpleaded and unargued basis and failed to make crucial findings of fact on pleaded matters that were in issue. I agree that the attempt to cobble together another part of that case was misconceived, but then they remit the case. I don't think our case is one where crucial findings of, well, depends on
On one view, yes.
view you take.
On the view I was sort of airing with you a moment ago, yes, because we're not told what the judge would have thought anticipated opportunities or revenue or anything else were at December 2017.
Yeah. All right. Well, anyway, that's that case, and then the other one is even more recently. In fact, the next one in the bundles, the Charles Russell Features case. Just to remind you what that was about, this was a case. You'll see this from the head note at 364. This was a case of an action on unpaid invoices, and the claim was made on the basis of an engagement letter, and so it was an express contract engagement letter claim. But the judge then decides that he's going to find in favour of the claimant on a quantum merit. And the upshot is, if we go to the end, if you go to paragraph 80, given that I accept that the judge's error in relation to the pleadings did influence the respondent not to apply to amend, in my view, it would not be the proper course to enter judgment for the appellant. The proper course is to remit the matter for a retrial before a different judge. The application to amend can then be determined, etc. Obviously, so that was a case of, anyway, the circumstances are different, but it also results in a retrial. So that's my postscript. And I'm now turning on to the third issue, which is the notice point. It's the wording of the clause, which is, if you want to have it in mind, in the core bundle at page 180. And I'm going to be addressing this under three headings. First of all, a bit about the legal approach to a notice clause. Then the question of notice of breach, which I can indicate, since it's a legal point, and whether or not my learned friend protested, I'm not going to be taking the point that you shouldn't be dealing with it. It seemed to me to be inappropriate to do that in the light of the position I'm taking on the other issues. And then thirdly, the arguments in relation to the amount claimed. So a few legal points in relation to the legal approach to a notice clause. The submission that I seem to have made before Lord Justice Newey in a different context is written agreements are all construed in the context of the particular case, and in the Hopkinson case, which you were taken to by my learned friend, that starts at page 200. In that case, that's the one where at the very end of the judgment of Lord Justice David Richards, as he then was, we've got paragraph 52 on page 210, and that's the paragraph with replete references saying that looking at other cases doesn't help you. There are a couple of principles that I take from the Nobaha case. That's the that's back at give you the page reference. It's page 163. It's the one where the principal judgment was given by Lord Justice Briggs. And the first point, there was another share purchase agreement case. The first point I'd like to make is by reference to page 16, paragraph 18. Now, the whole paragraph has been sidelined, I can't remember by my learned friend or I, but the principle that I extract from this is on page 169, 5 lines down, just against B. The parties are not likely to be taken to have intended to cut down the remedies which the law provides for breach of important contractual obligations without using clear words having that effect. And then that's both from Lord Diplock and elsewhere. So this is, if in fact the court's of the view that there's been a breach, then you don't likely cut that down. And that sort of feeds into the contra proferentem point, which is that if you look at paragraph 21 on the same page, where he says, I approach the issue as to the construction of clause on the basis there remains a principle that an ambiguity in its meaning may have to be resolved by reference to the narrower construction if linguistic, contextual and purposive analysis don't disclose an answer to the question. So contra proferentem isn't sort of first in line, but it's still living on in the view of Lord Justice Briggs. Although I'm not sure that the other two judges, I don't think I need to take you to them, I'm not sure that they place so much weight on that. They just look at all the general principles as to construction. You get that out of page 174. Now, there actually aren't many cases where I can find where the notice was found to be so deficient as to be invalid. Because, of course, if it's invalid, I agree that then, since it's a necessary precursor to an action, that the action is dead. And but the case which was found to be the notice was deficient is one that the learned friend touched on. It's the Tioco case, which is at page 189. It's a case in which my Lord Justice Newey delivered the legal judgment, the only judgment effectively that was agreed. And just to set the scene, in the head note, if you go about halfway down H3, there was a schedule that provided a claim couldn't be brought under tax warranties in the tax covenant. In February 2015, the purchasers wrote to the sellers purporting to notify them of claims which they described as either warranty claims or tax claims arising from tax liabilities in Brazil and the Philippines. The letter made general reference to the tax covenant, the general warranties and the tax warranties, didn't specify the particular warranties that might have been breached, nor particularise the facts alleged to constitute the breaches. And then there was another letter that again failed to identify the warranties breached. And then if you look at the head note, you'll see that it was said that every notification clause in an SPA turns on its own meaning, and
wording. Turns on its own wording.
Sorry, wording, you're quite right. And then the particular basis under which I perceived that this case was decided was 3 lines up from the end. In general, setting out the grounds of claim require explicit reference to particular warranties or other provisions. In other words, you can't really give a notice of a potential breach of warranty claim if you don't actually say what is the warranty that you're relying on. And that seems to have been the basis of the decision. And there's a bit more about that in paragraph 27 on page 198. And if you look right at the bottom of the page, very last sentence of 198, it seems to me that setting out the grounds of a claim required explicit reference to particular warranties or other provisions, and an omnibus reference to warranty claims. So that is a case where the notice was ineffective, but for a rather sort of very basic reason, although the arguments seem to have ranged rather more widely than that decision. So that's all I intend to say about the legal points. Secondly, we've got notice of breach, and the wording of the clause. I can go to the core one, and it's page 180. So it's 11.4, and it starts off, the seller shall not be liable for a claim. And then the learned friend says, well, we should look at the definition of the word claim, which is on page 163. That means a claim for breach of any of the warranties. And I think he then makes submissions based on the singular as opposed to the plural. If this is going to be an important point, I probably should draw to your attention that amongst the definitions in this agreement, if you go on to page 169, paragraph 1.6 in this long list of definitions, unless the context otherwise requires, words in the singular shall include the plural and the plural shall include the singular. So if your approach to 11.4 is going to be dictated by a particular definition, you've got a couple of different definitions there. But returning to the language of 11.4 at page 180, the sellers are not liable for a claim unless notice in writing. So I tend to sort of put little lines in when I'm doing these things. So unless notice in writing, so it's got to be written, summarising, so we're talking about a summary exercise here, the nature of the claim. So I would respectfully suggest that, or submit, that the threshold here is not a high one. It's calling for a summary of the nature of the claim. And then, while I'm still reading, this is relevant to the next point, and insofar as known to the buyer, and then as far as reasonably practicable, the amount claimed. So if we come to what we've got here, my learned friend did refer to one case as being pertinent to the wording, and I'm not sure whether it's pertinent to refer to it here or later, but I might as well deal with it now, because he took you to a case on what is reasonably practicable, and took you to the London Underground case, which is in the bundle of authorities, page 43. I suggest or submit that you won't really get much assistance from this case, whatever it decided, in the context of our case, because we're concerned with a particular provision in a party's contractual agreement, whereas the London Underground case was concerned with the construction of the words in a statute. And when approaching the words in the statute, the Court of Appeal was having regard to the nature of the approach to this type of case about time limits. And there's a line I'd like to show you in the judgment of Lord Justice Peter Gibson, which is page 51 of this bundle, internal page 117, just above D. There's a line that says, time limits in employment cases are in general strictly enforced. So whatever was said about the meaning of those words in this context, you have to bear that in mind. And the other point to bear in mind, so far as the decision of the court is concerned, is that the Court of Appeal was very reluctant to interfere with the holding. So if you now go to the judgment of Lord Justice Waller, page 52 of this bundle, internal page 118D, he says, I start from the position, as does Lord Justice Peter Gibson, that it's rare indeed for an appellate court to interfere with the finding of an industrial tribunal in this area. And then there's some authority that's referred to. So, with due respect to my learned friend, it's doubly, if not triply, unhelpful to try and get guidance on the meaning of our clause from the reference to that case. And the notice in our case is really what matters. You've got to look at the notice, and then you've got to test it by the words, does it summarise the nature of the claim? And the notice that we've got is in the supplemental bundle at page 300. Right at the end, I think. And I'm not going to read all of this out, I just wanted to emphasise certain points. So it starts off by referring to the fact that notice has to be given under the agreement, under 11.4. It then sets out the provision at clause 10 about warranties. And then it introduces, at page 301, the warranties, including warranty 19, and including the bit about prospects. So Lord Justice Newey's test is satisfied in the context of this notice. And then the nature of the claim is over the page, warranty 19, and has been already pointed out. This bears a close resemblance to the particulars of the claim. And so there's reference in the body of this to the pipelines at little c and little d, and it's said that there have been breaches of warranty 19.1.2, and then over the page paragraph 7 on page 303, whilst prospect isn't defined, it's not a recognised accounting term, and then it's the assertion that breach is given, there has been a material adverse change in the turnover, which wasn't properly reflected in the pipelines. And so what is...
Just to be clear, I think I said to Mr. Lowe, what you mean there is we can't judge the prospects in 2018 from these documents because they're flawed. Is that what's meant?
Yes.
Yeah.
And what is expected of a particular notice provision, obviously in the end depends on that notice provision. But it's important that you don't elevate the provisions for a notice provision into the requirements for a pleading. This is to give a warning of a claim within a particular time limit. But anyone who receives this knows that there is a breach of or is alleged to be a breach of the prospects warranty, and it's concerned with the prospects that, amongst other things, are set out in the pipelines. And then there's a lot of detail which I don't want to go through. Whilst I'm on the document, so I don't have to come back to it again, paragraph 45 on page 311, there is the contention, so far as is reasonably practicable, buyer's calculation of the amount claimed pursuant to the clause, the breach of warranty clause, is that figure, and that's given by the enterprise value minus the adjusted enterprise value. We don't need to worry about 46. The judge didn't order anything for that. So we then say, standing back in relation to the notice, it was very thorough, and does it summarise the nature of the claim? Well, it does, because it explains that there's a claim for the breach of the prospects warranty, and gives some further detail by referring to the pipelines. And it's a summary of the nature of the claim. And it doesn't need to do any more than it does. And for what it's worth, this was the view of the judge, who said in his PTA judgment, which is in the core bundle at page 236, but the relevant portion is on page 237. And it's the middle of the page. So it's the second paragraph. Mr. Lowe's second ground is the inadequacy of the notice of claim. Very conscious of the points made at trial in closing submissions, the importance of notices. Mr. Lowe says the claim made at trial differs substantially from that set out in the notice. I don't agree. The terms of the notice were very clear. He identified the warranty, set out the grounds. Anyway, so his view was that the notice was adequate.
I mean, to be fair, I'm not sure Mr. Lowe says the claim put at trial differs from the notice. I think he says the claim that the judge found made out differs from the notice.
No, I accept that, and that was occurring to me as I was reading. But the last of the points under notice is the amount claimed, and this, as I understand it, partly turns on the language of the clause. If I go back to that. I think it's page 180, yes, in the core bundle. So it's, as the quantum part, it has to be so far as is reasonably practicable, the amount claimed. And the first point of construction that arises is it required to give separate figures for, as a matter of language, for 11.4? So the first part is talking about liability for a claim, and Maloney Friend is contending that means each and every claim must be summarised, the nature of. But the point we're on now isn't that. The point is, and it goes on, and so far as reasonably practical, the amount claimed. So would it not be, if we were talking about more than one claim, amounts, or amount with a little s at the end? We do not accept that it is required by this wording that there needs to be anything other than the total amount that is claimed. Because that is what, in the end, the recipient of such a notice would be concerned about. What is their exposure? Maloney Friend surmises that somebody might get a notice and they might want to deal with one part of the claim as opposed to another part of the claim. But if that's so, all they've got to do is write a letter saying, are you able to help me more with what you're saying? But the ultimate question here is whether it is necessary to give more than the overall exposure, the amount claimed, and we suggest it isn't. But if we're wrong about that, then the amount claimed means amounts claimed, then we only have to do that as far as is reasonably practicable. And we're then into the debate that took place before the court yesterday afternoon about impossibility and what all that means. And we're into the judgment at paragraph 193, which is on page 237. No, not 237. 193 is on page 80 of the core bundle. And I think the court looked at this yesterday, and the judge is making a finding that it's in reality not possible to give more than one figure. And there was obviously quite a lot of evidence. You haven't been taken, understandably, to the entirety of the evidence given over a number of days. Mr. Lowe, in his usual industrious way, has taken you to snippets by way of documents and extracts from the transcript. But the judge expresses a factual view, which we simply say the attack on this doesn't meet the very high hurdle that's required on a factual finding. The judge was appraised of the potential challenge to this, and he says he addresses this in his permission to appeal judgment. And he does that on page 237 of the core bundle. And he says the question of whether a particular notice was defective can be answered by the particular circumstances. There are circumstances in which a blanket figure wouldn't be appropriate. The notice provision was quite clear, quantification had to be reasonable. This is where we got into the debate over reasonable or not. The question here is simply whether it's arguable the blanket figure given was not reasonable. I think he's actually setting the bar rather to, well, he's being harsh to my clients there, because surely the issue is whether the test is, the notice is good or not. What he does is he answers his own question as to whether the test in the wording is made out. He says the issue was addressed in the explanation. Anyway, we know what it says, and he simply underscores, having the opportunity to do so, the comments that he's made in the judgment. And so we say there's nothing in the notice point. And I look at the hour, but I actually think I will be able to deal with the last ground in the suitable time available.
So much the better.
So the last ground is the challenge as to part of the quantification of loss. And the basis for the calculation of the damages was agreed by the experts. We know that because we are told that at paragraph 197 on page 81 of the core bundle, and we are told that both parties proceeded on the basis the correct approach was to ascertain the value of the company, as it would have been mutually expected, and ascertain the value, and they have the difference between the two. And the judge says he thinks that is the correct approach, and then he sets out all kinds of principles that he's going to be applying. I don't understand any of the principles to be challenged. The attack is on paragraphs 207 to 209, what the judge calls the first stage. And my response to the challenge here is twofold. The judge, first of all, had the opportunity to address Mr. Lowe's point fairly and squarely in his judgment. And he spells it out fairly and squarely in paragraph 208, but he is against Mr. Lowe. And he explains why. He says the invoice was created in February in unexplained circumstances, and he thinks that it belongs along with the NIDEC figures in Mr. Dearman's adjustment. So although Mr. Lowe says he doesn't accept what is said, the judge is making a deliberate choice to take account of this extra figure and including it in the adjustment that Mr. Dearman made. So that would be sufficient to end this challenge. But in fact, Mr. Lowe returns to the fray by renewing this point in the application for permission to appeal. And so the judge has another opportunity to consider this, and this is the end of the permission to appeal judgment. So it's page 238 of the core bundle, the very last paragraph. So this point was rerun before the judge. I don't think there's any reasonable prospect of establishing 32,700 invoiced in respect of work done in August and September was not correctly dealt with in the claimant's expert's report, as set out in my judgment. Further factual evidence will be necessary to determine this point, which was not available at trial. So the defendants have a go, and they fail, and then they invite the judge to look at the matter again, it being an issue of fact. And he does, and he rejects the challenge. So there's been a double decision on fact. And it would be a very strange scenario that a conscious decision, this isn't said to be some kind of mistake, but a conscious decision by a judge to come to a particular finding is so outrageous as to be one that this court should interfere with. And it's not. And so this particular challenge fails. Those are my submissions.
Thank you very much, Mr. Warwick. So we'll come back to Mr. Lowe for any reply.
I'm grateful.
Court rise, if able.